Oh yeah, she's cute. Hi, my name is Alicia. I'm a real-life lawyer, and I'm on a mission to demystify the law and how it affects your everyday life. Today we're filming a Get Ready With Me video where I put on makeup while talking about an important Supreme Court case. As you can see, we are still in mourning. Why? Because the great Ruth Bader Ginsburg died on Friday, September 18th, and I am sad and clearly still exhausted. So continuing in mourning, we're gonna do a bit of a spooky little look today, and by spooky I mean I'm going to put on black eyeliner and that's about it. And in honor of RBG, I'm going to be talking about an important Supreme Court case called Frontiero v. Richardson. This is in honor of Ruth Bader Ginsburg because this is the first case for which Ruth Bader Ginsburg argued in front of the Supreme Court. It's also important in the history of women's rights in the law and under the Constitution, and she played a huge role in that trajectory as well. So let's talk about it. As always, I'm a lawyer, but I'm not your lawyer. Nothing that I say should be construed as legal advice, and you should always seek the advice of a licensed attorney if you have any legal questions. If you find this video helpful or entertaining, please give it a thumbs up and subscribe if you want to hear more from me. Let's get down to business. Here's the background. Sharon Frontiero was a service member in the armed forces. She was a lieutenant serving in the U.S. Air Force in the early 1970s. At that time, the U.S. Air Force had a policy wherein service members could receive additional benefits, such as money for living expenses as well as medical and dental benefits for their dependents. For male service members, however, their wives were automatically considered to be their dependents, and they just got those benefits. However, for female service members, they had to apply to get benefits for their husbands and prove that they were providing more than 50% of the support for the household. Sharon Frontiero had applied for benefits for her husband, who was her dependent under these standards, and was denied, so she sued. This was in Alabama in 1972, and she sued the U.S. Secretary of Defense seeking an injunction. You'll remember from previous videos that an injunction is simply the court telling an entity that they can or cannot do something. So Sharon was asking the court to tell the U.S. Secretary of Defense that he couldn't enforce this discriminatory law. So the central question in this case is whether or not this discriminatory treatment between men and women service members violates the Fifth Amendment due process clause. We've talked about the Fifth Amendment in a previous Get Ready With Me video, Korematsu versus the United States. I'll link it right here. But just as a refresher, the Due Process Clause of the Fifth Amendment says, and I quote, "No person shall be deprived of life, liberty, or property without due process of law." Oh yeah, she's cute. So there's two types of due process, and that's something we have not gone over. So let me break it down for you, really basic. I don't even have a mirror. Unbelievable. Oh God. So the two types of due process are substantive and procedural. We have already talked about procedural due process also in that Korematsu video that I made. Honestly, I've been using these vitamin C products, and I really think that my skin has just evened out so well. What a dream. So procedural due process is just the literal procedure, judicial procedure that you are due under the Constitution. And you'll remember in Korematsu that generally the process that is due is notice and a hearing. Basically, you get to have your day in court. So we've already talked about procedural due process before, again, in that Korematsu case. Substantive due process, however, is about, well, the substance of the law in question. Basically meaning that you can't be deprived of life, liberty, or property without being given a good enough reason. Typically, that good reason just needs to be that the law is rationally related to a important government interest. That's about it. And that's a really low bar, which is pretty easily met by most laws. Like literally the government just has to have some reason that is tied to reality for passing the law. Courts are usually going to defer to that. That's because we want the laws to be made at the legislative level and not at the court level. Courts aren't meant to make the laws, they're just meant to interpret the laws. So if there's any justified reason of any sort for Congress to have passed a law, the courts are generally going to uphold it. However, there are certain situations where the laws are going to be looked at with a higher level of scrutiny because of the substance of the law. So when the law discriminates based on a suspect classification, that is some part of your identity that you can't control, and we'll get to that in a second, then that's going to be subject to a higher level of scrutiny. Now, not all parts of your identity are going to be considered suspect classifications. For example, age is not a suspect classification, meaning that a law that discriminates based on age, someone of this age can do this, but anyone over this age can't do this, it's not going to be subject to anything higher than just a rational basis or the lowest level of scrutiny from the courts. However, I mean, we do have laws in this country that bar against ageism and discriminating based on age and things like employment, for example. But on the constitutional level, speaking purely for the Supreme Court and constitutional law, there is no protection against ageism, for example. But there are a specified list of suspect classifications that the court's going to look at with more scrutiny if a law discriminates based on these classifications. At the time of this opinion in 1973, it had been established that race was a suspect classification, meaning that if a law drew a line in the sand that differentiated or discriminated against people based on race, then it's going to be subject to a higher level of scrutiny. In the case of race, that level of scrutiny is called strict scrutiny, and it means that the government is going to have to show that the law in question that discriminates based on race was necessary to achieve a compelling government interest. So you'll see that this is a higher level than the rational basis test. You'll remember the rational basis test was just that the law was rationally related to some important government interest, whereas with strict scrutiny, the law has to be necessary to achieve a compelling government interest. So this is a really high standard of scrutiny, and most laws that discriminate based on race and they're put to this strict scrutiny test do not pass it because it is such a high bar. So basically what Frontiero is arguing in this case is that sex should be considered a suspect classification and be subject to the same level of strict scrutiny that race discrimination is subject to. A 3-judge panel from the District Court of the Middle District of Alabama did not agree. They said that the law only needs to be held to the rational basis standard, and it passed that here, and so the law was not unconstitutional. Because the government had the quote-unquote rational reasoning that by requiring women to show that their husbands are actually dependents, they're saving money. And that was rational. Which, under the rational basis standard, is true. That probably would be considered rational. Like I said, it's a really low standard. Congress just had to have had some reasoning. Obviously, Frontiero was not chill with that answer, and so she appealed it all the way up to the Supreme Court. So Frontiero was represented by an attorney named Joseph Levin, who worked for the Southern Poverty Law Center. She was not represented by Ruth Bader Ginsburg. Ruth Bader Ginsburg represented the ACLU as an amicus curiae, or amicus curiae. The thing about lawyers is we love to use Latin, but we don't actually know how to pronounce it, so everyone kind of pronounces it differently. Here are some fun examples of lawyer Latin that we love to just butcher. Prima facie, sua sponte, de facto, de minimis, actus reus, mens rea, ad hominem, ad infinitum, arguendo, inter alia, caveat emptor, certiorari, dicta, in limine. The list goes on. Comment below if you want me to make a whole video about lawyer Latin, because it's fascinating. Anyway, so RBG is representing the ACLU as an amicus curiae, which means friend of the court. Basically, what an amicus is it is a non-party to a litigation. So she wasn't representing Frontiero, and she certainly wasn't representing the United States or Richardson. And they come in before the court and they give the court briefs or sometimes oral arguments to explain areas of law, and the court can allow them or disallow them and take them into consideration or not take them into consideration. The court has a lot of discretion in this area. RBG was working in this area for the ACLU at the time, and so she was on the case, and she ended up arguing in front of the Supreme Court in support of the amicus brief that she submitted with the ACLU. And she argued, like I explained, that sex should be a suspect classification and that discrimination based on sex should be held to a higher level or strict scrutiny when the court determines whether or not the law is constitutional. So this was argued in 1973, and usually when someone is before the Supreme Court, but also a lot of judges, and they're making an oral argument in defense of whatever they've submitted to the court, often the judges will interrupt and ask questions. It's a lot of back and forth. It's a lot of the judges kind of challenging the lawyers to better support their position and to clarify legal questions that the justices might have, things like that. However, when RBG spoke that day, she spoke for just over 10 minutes and she wasn't interrupted a single time. And I mean, you can listen to the oral arguments, I'll link them down below, but it might have been because she's a really great speaker. I mean, I think she's captivating. I think she spoke so profoundly and articulately and with such good pacing, honestly, just from like a basic public speaking standpoint. But she was just so well spoken that it could have been that the court was just like spellbound by her and just didn't have any questions because she just was so well spoken. Could also have been that she was a woman speaking in front of the Supreme Court, which was made up of all men at that point, and they didn't really care that much, so they just kind of let her speak and then moved on. I don't know. The cynic in me wants to believe the latter, but the optimist in me wants to believe the former. So she spoke for over 10 minutes, and she ended her argument with a very iconic line that a lot of people like to cite from her, and I will just let her read it for you.
In asking the court to declare sex a suspect criterion, amicus urges a position forcibly stated in 1837 by Sarah Grimke, noted abolitionist and advocate of equal rights for men and women. She spoke, not elegantly, but with unmistakable clarity. She said, "I ask no favor for my sex. All I ask of our brethren is that they take their feet off our necks."
Again, I'll link the oral arguments down below. It'll be linked to a site called Oyez. If you have any interest at all in the Supreme Court, I would highly suggest that you check Oyez out if you haven't already. It has a archive of all of the oral arguments that have been recorded. It has a background on every single US Supreme Court case that has been argued. It's super well laid out, super easy to follow, and has all the information you could ever want to know about any Supreme Court case. So I'll link that below and you can hear her argue in front of the Supreme Court. All right, so what was the court's decision? The court agreed with RBG and the plaintiff. Frontiero won the case. The court determined that gender is a suspect classification that should be held to strict scrutiny, just like race. And they said that the law in this case does not pass strict scrutiny, that this justification that the government used of, you know, saving money and making the system more efficient did not reach the level of strict scrutiny, and that the Constitution was concerned with much higher issues than just efficiency. I'm gonna do the liner off camera because you guys, you make me nervous when you're watching me, and this has to be a good straight line, all right? Don't look. All right, I did it. Don't want to talk about how long it took me, but the point is we're here, and that's what matters. Okay. Where the heck were we? In this case, the court applies strict scrutiny since the law doesn't pass it. Their rationality, not good enough. However, I will note that after this case was decided, there were subsequent cases that came along and actually lowered that level of scrutiny. So now, gender is still a suspect classification. However, there is a new level of scrutiny that any law that discriminates based on gender has to pass, and that is called intermediate scrutiny. So it's not as high of a bar as strict scrutiny, but it's still a step above a rational basis. Basically, to show intermediate scrutiny, a government will have to show that the law was substantially related to an important government interest and was narrowly tailored to achieve that interest. So not necessary and compelling interest, but still more than just a basic, any rational basis at all. God, why does my mascara look like shit? As part of the opinion, Justice Powell wrote a concurring opinion saying that he agreed with the outcome of the case, but thought that the court should not be making a determination on whether or not gender is a suspect classification. And the reasoning partially for this was because Congress had just passed the ERA, the Equal Rights Amendment, which was on its way and seemed very promisingly to becoming a constitutional amendment very shortly. However, as you may know, the ERA actually never was ratified, so I guess it's good that they made a determination. But alright, well, I need new mascara because this shit is clumpy. I guess that's what happens when you go for 6 months of quarantine without wearing any makeup. Again, the ERA was never actually ratified, but I wanted to give that context because it's important. Did I kill it? God damn it. I'm gonna kill that fly. I'm gonna kill it dead. But I just wanted to give the context of this case. The Equal Rights Amendment had been this huge national movement that had led to the passage of a new amendment in Congress, and Roe v. Wade was decided the same year that this case was decided. There was a lot of momentum and a lot of work being done to propel women's rights into the forefront of the national conversation, and Ruth Bader Ginsburg played a huge role in that. So basically, this case was a huge deal. Ruth Bader Ginsburg was a huge deal, and she played a pivotal role in not only this case, but the trajectory of United States history and its treatment of women, which is why I wanted to make this video and why it's so important to honor the legacy of Ruth Bader Ginsburg, and RIP Ruthie. Thanks for watching. I hope you enjoyed this and found it educational. Please give it a thumbs up and subscribe if you want to hear more from me. Comment below if you have any ideas for future videos. Thank you so much for watching. Have a good day. Goodbye. Oh God. Oh, I hate it. Oh.